SJC-11375, Commonwealth v. Omay, Tavares.
Okay, Attorney Campbell.
Thank you. Good morning, and may it please the Court. Kaylin Campbell on behalf of the Commonwealth. We ask you today to reverse the allowance of the defendant's motion for a new trial.
Okay, now, Attorney Campbell, I kind of think you have an uphill battle here. So can you address the precise standard of review we should use and what the evidence against the defendant is, putting aside all the stuff that related to the CI and the third-party culprit? Anything other than that?
Correct. So the correct standard that you should use, I believe, is the standard that was recently articulated in the Eng case, which is the typical Safarian standard, because this is not the defendant's direct appeal. I disagree with my sister's argument that that lessens is somehow less, well, that it is somehow unconstitutional because it lessens the burden, because that is the standard that's given to every other criminal defendant. I would say, though, that the standards, though they say that the 33E standard is more favorable, it's hard to articulate exactly how that is. I don't really think when you look at this case or apply sort of what happened and how the judge erred to this case, that that is a dispositive factor in any way. That's not to say that I'm urging the court to get rid of the holding in Eng. I think it is the correct holding. But that being said, even if you were, I don't believe that it changes the outcome of this case.
So basically you're saying whichever one we used, we'd reach the same outcome?
Correct.
For good or for ill?
For good or for ill, as to me, yes. Yes, and I will candidly acknowledge this is not the easiest case that I've argued before the court. Still, nonetheless, I do believe that the judge erred, and I do believe that the defendant ultimately received effective assistance of counsel. Now, as to the information that's at question here, I think it's important to look what that information is. I'll refer to it as the proffered evidence, just for ease of discussion, and it comprises of 3 documents. It's important to note that each of these were exhibits, so the court can look at them de novo. You're not bound by any credibility determinations that the judge may have made as to those documents. And the documents, when read in combination, which I believe they must be, and which defense trial counsel testified he got them together, received the information together, reveal that it leads to the very first error that the motion judge made, which is what that information actually was. And I think that's critical to the analysis, right? What the information is and what the information isn't. What it is that on September 23rd, which is approximately 2 weeks before the defendant's trial, the Commonwealth had a proffer session with C1, who was in federal custody at the time. He relayed that the murder was committed. He got information. He says that there's an individual, I2, who provided the gun to HH, who committed the murder with a man who was unknown to C1, which is later described as the man who had been arrested for the murder.
Well, before we go through just how many layers of hearsay that is,
Correct.
and before we recognize that there's also the layer that it's in a report.
Correct.
So that adds a layer too.
Correct.
Let's deal with the first prong here. So there's information that the firearm is in somebody else's hands. The motive is different.
I disagree with you there. If you read it carefully, and my sister and the motion judge refer to it as putting the gun in somebody else's hands. Yes, the information says that he obtained the gun. It's silent as to who actually committed the shooting. It says he brought the gun to the scene and there was a dispute. It doesn't actually say who the shooter was.
Does that matter?
I think.
Does that matter in terms of the test of ineffective assistance of counsel? Because if that were true, wouldn't a defense attorney find the answer out, or at least try to investigate the answer before trial? I mean, irrespective of that, right? Like, you get this information that potentially somebody else could be the person who shot. And again, there's another point to this where that there's no indication that this was a joint venture. So whomever the other person, it would be a big deal to know who actually shot, wouldn't it?
So I disagree because the proffered information itself suggests that it was a joint venture. You're right. The facts and the investigation at that point by the Commonwealth had not suggested that it was a joint venture, but the proffered information suggested it does. I think at the end of the day, and this is what trial defense counsel testified to, he viewed it as more, not less evidence of his client's guilt, albeit a different theory. And I think you have to look at that information at the time he received it, at the eve of trial, and that he viewed it as more, not less evidence of his client's guilt. And that's what makes this case really different from most
But may I ask, what's the standard, though? And we're not, it's not subjective, right? So it's an objective standard.
It's not. It's interesting because I think it depends. The way that I look at it, there are sort of three potential avenues of ineffectiveness for the use of this information. There's a failure to investigate, there's a failure to ask for a continuance, and there's a failure to use this information at trial. As to a failure to investigate, I would say the case law is somewhat confusing. If you look at a case like the Lang case, it is a plurality. It breaks down different ways that you could view it. If you look at Justice Hines' concurrence, it says, and Justice Legg's concurrence says the same. It says you have to look at whether the decision was reasonable at the time, and it's reasonable if reasonable professional judgment supports the limitation in investigation. And the question that you ask is reasoned choice whether further investigation was warranted, and you look at it from counsel's perspective at the time that the decision was made, not with hindsight.
And counsel says that at the time he made the decision not to ask for continuance or investigate this, the reason was that he didn't think that the other witnesses would be available.
He didn't think the other witnesses would be available. He did say he viewed it as more evidence of his client's guilt. He viewed it as inculpatory as opposed to exculpatory evidence as well.
And how does that reasoning work? That it's more inculpatory than exculpatory?
Well, I think that reasoning works if you're asking whether it's a reasoned professional judgment. You have to look at, is this evidence truly exculpatory, which most cases, in a more classic sense. It's not that I'm saying that this isn't exculpatory evidence.
How can it be a reasoned, practiced, whatever the term you use when you don't have all the information?
A reasonable professional judgment. Well,
So if I'm going half cocked and don't know what's going on, how is it a reasoned judgment?
So first, I would disagree that that was the situation here. Second, I would say if there was evidence to prove that, then no, it wouldn't be a reasoned professional judgment. I would say here what defense counsel was presented with was evidence that he viewed as more inculpatory than exculpatory, and he went forward.
But he never talked to anybody. How's he know?
He didn't. I would agree with you there. I think even so, then, that sort of collapses into the prejudice prong.
Well, let's wait, before we get to prejudice, just on the obligation to investigate. I know no one saw the shooting, but Braxton and Brown say there's one perpetrator. And all of a sudden, in your hands, right before trial, you find out there's going to be evidence that there might be two. Don't you have to sort of get up off your seat and look into that?
So I'd say I disagree with you factually with one aspect of that, and Brown says one person comes, he lets one person in, he leaves, he's not there at the time of the shooting, so he can't.
I understand neither of them see the shooter, but
Correct.
The whole theme is one person.
The whole theme is there is one person.
And that person goes by O.
That person goes by O. I think it's important, too, the motion judge focuses a lot of the decision, especially where it gets to prejudice, on I-2 and how I-2 is also O, but there's no information elicited that I-2 was there at the time of the shooting, that I-2 was the shooter. To the contrary, I-2 is pointing the finger at HH and inferably the defendant. Now, as to whether you have to investigate it, this is an interesting question in the abstract as well, right? Because at the base of it is all of the evidence that was elicited in the investigation and then through this is that the defendant committed the murder. Now, this evidence is that he committed it with somebody else, but because it is still that the defendant committed the murder, it is not as easy as some of these cases in which it's a more complete defense, a mental health defense.
It's not your fault the defendant attorney didn't do any investigation, but gee, I mean, don't you have to at least find out what's going on here and make a professional judgment?
You could, I mean, we are left with what this trial counsel testified to, which was that he viewed it as more inculpatory than exculpatory and decided to go to trial. I think playing in this as well, if you look at it at the decision, the time was made, if you look at the timeline of this case, this is his client had been in custody for almost 2 years at the time of this trial. This is not a case in which defense counsel hadn't done any pretrial investigation.
I thought it was.
No, if you look at specifically the docket, you'll see that pretrial investigation was done. Now, it wasn't done as to this proffered information, but there's a motion for funds for a ballistician, a motion for funds for a fingerprint expert, a motion for funds for a telecommunication expert. There's a motion for query and criminal history of all potential suspects.
But not for an investigator.
No, Attorney Himmelstein doesn't file a motion for an investigator. Previous counsel did file a motion for an investigator. There is no evidence as to what that investigator found through his investigation.
But didn't Judge Cannoni find there was no investigation?
She did, and I
Okay,
think,
isn't it over then?
I don't believe it's over, especially when you look at the docket, which refutes that on its face. I think there was an investigation as to this proffered information. The question becomes then, even if you find that the first prong wasn't met, whether that prejudiced the defendant. And again, this is a unique situation and not like most of the cases that we typically find because it does have this inculpatory aspect.
The inculpatory, so now he's a joint venturer in the murder.
Correct, but I think it's important to look at this practically, and I understand at first blush this is a case that is really uncomfortable, and it seems like there's a huge problem.
So let's count. The CI, tell me if I have this wrong. The CI tells the police officer that a hearsay declarant I-2 gave HH a 9mm firearm that HH was planning to use in a robbery, and that the police officer wrote that down, and implicit in all that is that I-2 is getting this information from another person. So if you count all those out, generously it's 4 layers of hearsay.
Correct.
Not generously, it's 5.
Correct. I also think, too, if you look at it in terms of the defense that was presented, this is a circumstantial case. There's no eyewitness who directly placed the defendant in this apartment. Ignoring the 3 to 5 levels of hearsay, this would be direct evidence that places the defendant in the apartment at the time of the robbery. So it becomes a defense. My client didn't do it. He wasn't there. There's a reasonable doubt based on the circumstantial nature of the pieces of evidence that are brought forward, as opposed to there is direct evidence that my client is in the apartment at the time of the
May I ask
robbery
you a
murder.
question? Did the victim's girlfriend, Braxton, testify at trial?
She did.
Did she identify the defendant as the shooter?
She did not.
She did not. Did she identify anybody as the shooter?
She was asked to do a photo identification, and she gives a description of the person who is in the apartment. She gives a description. It's somewhat vague. She gives a height. She says light-skinned, light build. She gives gray hooded sweatshirt. She sees him. She hears an argument. She comes to go look. He points a gun at her. She runs to the back bedroom. She's trying to get out, and that's when the shooting takes place in the kitchen.
Both witnesses discuss a single shooter, right? So the person that's there and the person who answers the door for the drug deal, there's only one person.
Correct.
Now we have 2 people.
Now we have 2 people, but it becomes direct, albeit hearsay evidence that defendant is in the apartment as attacking. He wasn't there. There's no evidence that puts him there. I think when you look at it,
Doesn't that, well, I guess this is the prejudice prong. Doesn't that substantially weaken the Commonwealth's case?
I don't believe so. I don't believe so. And the question is, as to the standard, the question is.
I'm thinking of the Cowles case where the person was in the bathroom and.
Correct. A serious doubt that the verdict would have remained the same. And I don't think you can say that because contrary to the motion judge's finding, if the defendant presented this defense, the Commonwealth would be able to rebut it. And the judge cautioned defense counsel many times, if you open this Bowden door, they're going to be able to tell all the reasons why they focused on the defendant. And if you...
Kinda.
Well, no, I don't think kind of, because if
No,
you...
I mean, that's discretionary, right? Because there's a Bowden defense, everything doesn't come in. We've told the trial judges that's the case, so the judge has discretion as to whether or not all that Bowden stuff comes in.
Absolutely.
Or Bowden anecdote comes in.
Correct. I think if you look at it, what evidence would have come in is especially given the timing of this proffer, that the police investigation focused on the defendant, the reasons why it focused on the defendant. They get this proffered information. There's problems with its reliability, both because it's multiple levels of hearsay and the person that's giving the information. But not only that, it corroborates key pieces of the defendant's case, which is the defendant was involved.
So I guess with all that uncertainty, the answer is investigate, right?
Right.
So then now we really deal with prejudice.
Correct. If you're asking sort of cautionary tale for defense counsel, should you investigate this? And would my job be easier had defense counsel investigated this? Absolutely,
Well,
yes.
you'd be in the other chair.
I would be in the other chair, which I far prefer, but the question really becomes whether the defendant was prejudiced, and where at the base of this evidence is that the defendant was still involved, was still the person that did it, where it is evidence that directly puts him in the apartment, and where it otherwise corroborates key aspects of the Commonwealth's investigation. At the end of the day, that's where I believe the motion judge erred, and that even if the first prong of Safarian was met, the second prong was not. I see him over my time. I'm happy to answer any other questions. Otherwise, I rest on the brief.
Do we measure prejudice based on this 4-layer, 5-layer hearsay, or do we measure it on if he had done an investigation, trial counsel might have been able to bring in HH, who would have corroborated that I2 is O, and yada, yada?
So, no, and that's a really interesting question. I think you have to look at it as the layers of hearsay, because it was the defendant's burden at the motion hearing to provide what an investigation would have resulted in. So a good example is the Lang case. They have a psychiatric evaluation, and they said, had a reasonable investigation happened, here's the evidence that could have been admitted. There was extensive pretrial litigation in this case. There was extensive post-conviction, there's extensive post-trial litigation in this case. There was extensive post-conviction discovery requests that were made. And none of this information bore fruit that there ever would have been any more admissible evidence other than what was here. And I'd say where it was the defendant's burden to provide that evidence at the motion hearing, and he did not do so, then we are stuck asking, okay, we have this 3 to 5 layers of hearsay. How would that have affected the verdict in this case?
I have a quick question.
Yes.
So our job is to look to see whether or not the trial judge made an error of law or abuse of discretion. Is that right?
Correct.
Are you saying that there's an error of law here or an abuse of discretion?
I believe there's an error of law. And the error of law is in this. Well, first of all, I think there's a clearly erroneous factual finding as it relates to the proffered information, which then that clearly erroneous factual finding is used in the analysis, which creates an error of law. And I believe the error of the law is, as with the first prong, I think you have to look at, well, I'll leave the first prong alone because I don't think that that's my strongest argument. As to the second prejudicial prong, I think the error of law is that it doesn't look at whether this created, and I just want to get the precise language, a serious doubt the verdict would have remained the same because it applies that erroneous factual finding to the case itself.
But is that an error of law?
I think insofar as the prejudice law as stated wasn't applied correctly, that would be an error of law. I think it would be.
Okay, thank you.
Thank you.
Attorney Billowitz.
Good morning. May it please the court. Elizabeth Billowitz for the defendant appellant, the defendant appellee, Omay Tavares. I'd like to start by addressing the argument that ignoring the proffer evidence was somehow a reasonable tactical decision. Trial counsel could not, as a matter of law, make an informed tactical decision about the proffer evidence at this stage. Because without a reasonable investigation, he didn't have enough information to evaluate his strategic options and make decisions in the best interests of his client. He had a duty to familiarize himself with the evidence, a duty to conduct an independent investigation, and here, as the motion judge found, trial counsel violated these duties 6 ways to Sunday.
Couldn't that be a reasonable decision if there's a time crunch, gets this information late, and there was truly a witness unavailable and the attorney says, I need to go now because I'll never get this witness. I mean, so you're talking absolutes, that when they get a proffer, you know, it's over, but I'm not so sure it's an absolute issue if the attorney said, based upon the circumstances in front of me, given the availability of my witnesses, et cetera, I need to go to trial.
Well, the absolute first thing that he should have done was to seek a continuance. And this court...
But what if he sought a continuance and his best witness was gone?
There is absolutely nothing in the record to support that, and the motion judge, we explored that in the Rule 30.
Asking you not, I'm just
Hypothetically?
asking you about these absolutes you try to paint us into, saying if there's no investigation, therefore, it's ineffective.
Well,
Because lawyers get crazy proffers all the time, right?
I will accept that as a hypothetical, I'm sure, but this proffer put the gun in the hand of a different individual. It was, on its face, visibly, powerfully exculpatory.
What if there was information given to a defense attorney from the police? It's Bowden type information, and it says word on the street is, you know, somebody else did it.
Right. Again,
What do you do?
this case could not be more different. I would say,
Is it
I would say
ineffective not-
conscientious defense counsel would still seek a continuance. And
interview the street?
perform whatever investigation is appropriate. And in this case, the motion judge correctly enumerated several steps that he should have taken and considered the trial counsel's explanation at the Rule 30 hearing that he was concerned about his witnesses no longer being available if it were rescheduled. There wasn't anything specific that was offered there.
Those findings by Judge Cannoni we defer to, correct?
Yes, because she presided over the Rule 30 hearing.
An evidentiary hearing.
I'm sorry?
She had an evidentiary hearing, she made facts.
That's correct. And she made a point of assessing his credibility and competence at that hearing. So at the time that he was making this purported tactical decision on the literal eve of trial, he had seen only undated and highly redacted documents. He didn't know who I2 was. He didn't know that anyone's nickname was O. He didn't know the gang associations, the criminal backgrounds. And he just was not equipped to consider the complex implications of all of this and determine how it could have supported defenses. Even if he had looked into the proffer evidence, even if he did some investigation and found out what we know now, a strategic decision would have been manifestly unreasonable. The judge applied the appropriate deference to a tactical decision. She considered both the explanations that were offered at the Rule 30 hearing that the witnesses were ready to testify, and she also considered what I think is the Commonwealth central argument now, that the proffer would have done more harm than good because it referenced a second man who could have been Mr. Tavares. She rejected this argument, correctly concluded that the proffer evidence still was exculpatory. And this court recently explained in Pope that exculpatory is not a narrow term connoting alibi or other complete proof of innocence. It can be inculpatory in one light and exculpatory in another. All it has to do is provide some significant aid to the defendant's case. And here the proffer evidence was exculpatory really in all three ways described in Pope. It identified a different shooter. And
What's the it? When you say it identified a different shooter, what's the it? The it is 3 to 5 layers of hearsay, right?
Right. So content-wise, the proffer says that I2 provided a specific weapon to HH.
I2's not in the room telling the out-of-court declarant police officer who wrote it in a report. I2 CI is in the room saying what I2 said. I2 must have heard it from somebody else who was there, probably HH, and it gets written into a piece of paper. So, I mean, whether it's a fair and a substantial likelihood, you got a great argument on the first prong. But what's the second prong going to do for you other than bring the defendant into the room in a different way that adds an eddy to the final instructions and the closing argument?
So what the proffer said was that an unnamed man called the victim to set up a drug purchase, but actually was intending a robbery, and then went to the victim's home along with HH, who was armed with the Taurus, this weapon. And I want to be clear, I think there was some question about who really had the gun. The proffer does say that I2 provided the gun to HH, that HH was armed with the gun, and that HH then tried to return the gun to I2. So at no point does the proffer evidence ever have the gun in his hand. Does the second man have the gun in his hand? So given the specific facts of this case, this was profoundly useful to the defense, and I'd like to explain this with perhaps a little bit more precision than I did in my brief. So there was minimal evidence that Mr. Tavares specifically shot the victim, right? There was no physical evidence, no eyewitness ID, but there was considerable evidence that Mr. Tavares was calling the victim, and was possibly near or at the scene. The jury heard that there was just a single visitor that night, so it's not surprising that they inferred that the person making the calls was the same person who entered and shot the victim. Add a second person, that inference no longer holds, and the proffer would have provided...
About the text message, though.
Afterwards, the I got bagged.
Yeah.
That is arguably a statement that he was arrested. There was absolutely some consciousness of guilt in this case. And again, consistent with possible involvement, involvement does not mean liable for first-degree murder. So in other words, the proffer evidence would have given the jury a plausible narrative for Mr. Tavares possibly being involved, but reasonable doubt as to murder. I want to address the hearsay issues that Justice Lowy asked about. The judge correctly held that the proffer evidence, these documents, would have come in, were admissible under the hearsay exception for third-party culprit evidence, first of all. I don't think it matters how many layers are at issue. That exception is generously construed. All doubt.
You ever construed it across like 3 or 4 levels of hearsay?
Not that I know of.
No,
but
either.
Again, all doubt should be resolved in favor of admissibility. This evidence was undeniably relevant, wouldn't tend to prejudice or confuse the jury.
But there's no, we said...
I don't know about that one, where you have 4 levels of hearsay.
I don't know that that would have been confusing to a jury.
Certainly not third-party culprit because of the lack of a nexus, but as far as Bowden goes, I know we've been generous, but I don't know if we've ever been that generous.
Well, and the generosity, you know, the doubts resolved in favor of admissibility is for the third-party hearsay culprit, third-party culprit hearsay exception, and the judge identified another basis that doesn't relate to hearsay at all. It's not hearsay to introduce the proffer documents as Bowden evidence. And that is a simple balancing test. If the evidence is relevant to the adequacy of the police investigation, I don't see how you could say it's not here. It's admissible unless its probative value is substantially outweighed by the danger of prejudice.
You also have the issue that was raised by Justice Wendland's question to Attorney Campbell, that had he maybe pressed the CI motion, right, and done an investigation, that all of this hearsay might have been direct evidence, right? That if he had done all of this.
Exactly right. And I will point out, HH appeared in open court on the first day and trial counsel did nothing. So yes, he wouldn't have necessarily, had he done an adequate investigation, we wouldn't be even necessarily relying on these documents. I want to make sure that I address the joint venture question. The Commonwealth has contended that even if trial counsel used the proffer evidence, the jury inevitably would have convicted Mr. Tavares anyway under a joint venture theory. It's important to recognize this case was never tried as a joint venture. There's no mention at any point of a second participant. As this court noted a similar situation in the Alcide case. Joint venture was not argued or charged. We don't just swap in a new basis for liability and assume the result would be the same. The Commonwealth could have introduced this evidence itself if it wanted to pursue a joint venture theory. Even if it were tried as joint venture, a finding that Mr. Tavares was this unnamed man who set up the robbery wouldn't mean that he would be convicted of first-degree murder. There would have to be proof beyond a reasonable doubt that he knowingly participated in a murder and shared HH's intent.
I don't want to confuse things, but there possibly could have been a felony murder issue.
I'm sorry?
There could have possibly been a felony murder issue.
Yes, and again, this was not tried as such. The Commonwealth does point out correctly that an underlying felony doesn't need to be charged in order to supply a predicate for felony murder, but it does need to be supported in the record and instructed to the jury, and neither thing was done here. Robbery was not articulated as a motive in the case that was tried. It wasn't mentioned in opening or closing arguments, wasn't instructed. The only relevant item in the record was that the victim was seen with a wad of cash before the shooter arrived, put it away somewhere. I would just note that the Commonwealth really stretches this evidence in its brief and says that $500 was seen in the kitchen and then $500 was seen found in a jacket in the defendant's apartment. The amount was not this precise. It was just described as a wad of $500 to $800. Later, it's $1,000. So this is not something that should be relied on. So the motion judge was correct in concluding that neither joint venture nor felony murder obviated prejudice in this case. Regardless of whether Mr. Tavares was the second man mentioned, the proffer evidence still would have been helpful to the defense in casting doubt on the eyewitnesses' testimony, the Commonwealth's theory of the case, and the adequacy of the police investigation. The Commonwealth said in its brief that if defense counsel introduced the proffer evidence to question the adequacy of the police investigation, the prosecution would have countered with a devastating rebuttal. This is an empty threat. A Bowdoin defense could be rebutted by showing that the police did in fact perform an adequate investigation or that they had some good reason for disregarding it. It doesn't appear that the Commonwealth can show that the police took any steps to investigate the proffer because in post-conviction discovery, the Commonwealth is ordered to disclose that. Phone records, investigation reports, Form 26, et cetera, and the Commonwealth produced absolutely nothing. So it's a fair inference
It could also be
no such
evidence. It could also be evidence that didn't come into trial that points to the defendant's guilt, as well. Correct? That didn't come in.
Well, if the Commonwealth.
But was there any of that type of evidence in the hearing?
No. So the Commonwealth did not produce any evidence at the hearing, and if it had some good reason, if the police had some good reason to disregard the proffer evidence, it could.
No, I'm not talking about that.
Yeah.
So the other prong of that is they could rebut, they could say, this is why we didn't look at this other alternative view. Or it could be, this is why we focus on the defendant. This is all the stuff you didn't hear.
Correct.
Your position is neither of that was in the post-conviction hearing.
That's correct, and I don't know why, if the Commonwealth had that, I don't know why they would wait until a retrial. They simply could have introduced that at the Rule 30 hearing. The
It doesn't
motion
matter.
judge perhaps would not have found
Right,
prejudice.
it's not before us because it wasn't in the hearing.
That's correct. For all of these reasons, we ask the court to affirm the ruling of the motion judge, unless this court has any further questions.